Hello, I'm Scott Edward Walker, and I'm the founder and CEO of Walker Corporate Law Group, which is a boutique corporate law firm specializing in the representation of entrepreneurs. You know, I've been doing deals for over 15 years now, including nearly 8 years in the trenches at 2 major law firms in New York City. And what I thought would be helpful to entrepreneurs is to share with you 3 lessons that I learned in the trenches. So, lesson number 1, the importance of due diligence. Now, let me set the scene. I was a second-year associate at a major New York City law firm. Our firm was representing Sony in connection with its acquisition of CBS Records. It's a $2 billion deal. You know, there were about 7 or 8 of us on a due diligence team who were sent over to BlackRock, which is CBS Records' headquarters in New York City. We're there for about 2 or 3 weeks, going through boxes and boxes of documents from 8 in the morning till 2 in the morning. And we're young, we're inexperienced, we really don't know what we're looking for. But then we find what's called a change of control provision in certain of the contracts of major artists, such as Michael Jackson, Bruce Springsteen, and other major artists. So what was that? Well, those provisions provided that in the event of a change of control, for example, if Sony acquired CBS Records, those agreements would terminate unless the artists consented in writing. So obviously this was a very, very important provision for Sony, because if the artist didn't come along with CBS Records, clearly the value of CBS Records would be diminished dramatically. So that was my first lesson, due diligence. The second lesson that I learned, and now we're probably 3 months after that deal closed, I get called by a senior associate, pulled on to another major deal. We were representing the acquirer. The senior associate said to me, "Hey, Scott, you take a first crack at the acquisition agreement." You know, being the clever guy that I am, I get the Sony CBS deal. I get a copy of that acquisition agreement. I have my secretary run off a copy. You know, I'm marking it up. I'm folding in the new deal terms for this deal, changing the names, working pretty hard over a couple of days. I send it up to the senior associate. Maybe a day later, I get a call, "Scott, come up to my office," and I get chewed out. Why? Because I had mistakenly folded in all these seller-friendly provisions into this new transaction that carried over for the Sony CBS deal. You know, these were provisions that were negotiated by Cravath, which is a very prestigious law firm in New York City. They had represented CBS, and all these provisions that were in that agreement, I had simply carried over not knowing. So lesson number 2, be very careful about playing around with forms. You know, particularly if you're entrepreneurs trying to play lawyer, it's not the thing you want to be doing. The third and final lesson I want to share with you, it's sort of a subtle point here, but very important, is the importance of creating a competitive environment in connection with negotiating a transaction. So now I'm probably a 3rd or a 4th year associate. I got 2 big deals on my plate. In both deals, our firm is representing the sellers. But they're different contexts. In one deal, it's an auction. There's a multinational corporation divesting its division. We have an investment banker handling a controlled auction. There are a number of bidders. And the other deal was completely different. You have a private company, and it's being sold to a competitor. There's no auction. In fact, there are no other bidders, and the buyer knows that there are no other bidders. And they're represented by Skadden, which is a very aggressive law firm. And so the lesson here was, as the 2 deals progressed, we ended up with 2 different agreements. You know, the agreements that were signed up, one agreement, and that's the one with the auction, had a whole bunch of seller-friendly provisions. Why? Because the investment banker had effectively played the bidders off each other. So we got very, very strong seller provisions, such as broad materiality qualifications. The cap on seller's liability was 10%. There was a huge basket. In the other deal, because the buyer knew that the seller was anxious and we didn't have other bidders, we didn't have a banker, that became a very buyer-friendly acquisition agreement. There was a huge escrow. The cap on seller's liability was the purchase price. And so the lesson here was, when you entrepreneurs are going out and negotiating transactions, you have to understand the importance of creating a competitive environment, or get some experts or lawyers or investment bankers to help you. They understand that. So those are 3 basic lessons that I learned. I hope they're helpful. Again, my name is Scott Edward Walker. If you have any questions or comments, please just shoot them to me through my blog at walkercorporatelaw.com/blog. Thank you.